2 minutes. We were having a little technical difficulties.
Okay, no worries.
Minutes. We were having a little technical difficulties.
Okay, no worries. Did a playback or something.
Yeah, I was wondering. I was like, is that me?
Judge, if possible, I sent you a
I'm reading
message.
now. I was like, did he
Okay.
just send this? Okay, good morning.
Yeah.
I'm seeking a new court date as my former attorney and I have mutually decided to terminate our professional relationship. I was informed by my previous attorney I could not appoint a replacement until he obtained approval from the judge to withdraw from my case. Although he assured me that the court date will be rescheduled, he only informed me of the judge's permission on Saturday and that date will remain unchanged. Consequently, I am respectfully requesting additional time to engage in a new attorney who can represent me in this matter. Thank you. Attorney Thompson, that's what Mr. Turner just sent to me.
Okay, I figured it was gonna happen. I thought that it would have gotten addressed earlier, but no, I figured that was we were gonna do it.
Okay. Yeah, I see he just withdrew on 30th. Oh, your client dropped off.
Oh.
Yeah, he didn't notify me until I've been checking with him to see, what the status was, and he didn't notify me until Saturday.
Of this hearing?
No, not of this hearing, of his permission to withdraw.
Oh, I see what you're saying. So you didn't know he withdrew back in October?
Correct. I had requested it back in October. He said that he wouldn't be able to leave until he got permission, and I've been waiting for him to receive information saying he got permission because he said that the date may be scheduled. He said that with that permission, the court date may be rescheduled. But I didn't hear back from him, even though I requested. I even got email from him Saturday where he finally sent everything over.
Oh, wow. Yeah, withdrawing off a case doesn't necessarily mean it automatically gets reset. Do you have a copy of the order now, withdrawing?
Yes, I can pull it up. I have it via
No,
email.
I want to make sure you had it.
Yes.
Okay, okay.
I got it Saturday.
All right. Attorney Thompson, is there any objection to resetting the case?
We are seeking jail time, so no. I would say if you appoint him an attorney, no objection, because we are seeking jail time here.
Well, Mr. Turner, do you work?
Yes.
All right. Because if you were able to retain private counsel, 9 times out of 10, you wouldn't qualify for a court-appointed attorney. So yeah, we can reset the case. How much time do you all? Hold on one moment.
Okay.
Okay, so Mr. Turner, how much time you think you'll need to get an attorney?
With the holidays and everything, I'm thinking maybe like 60, 90-day window.
Okay. Oh, I can't see you.
Oh, sorry about that.
I was like, that's not you. Well, I mean, it is you. It's just a picture of you, character picture. Let's see. Let's see. So that will probably put us somewhere in the middle of February.
The more time, the better, given the situation.
All right. Attorney Thompson, how does your calendar look the March 4th?
I have a trial March the 4th.
Okay. Let's see. March 18th. These are in, Mr. Turner, these are first settings, meaning that you all will go first at 9 o'clock.
Okay. I'm sorry, Your Honor, March 18th.
Yes.
Can I 1 second to check the kids' school calendar?
Sure. Yeah. I know that spring break is most cases that week before.
Okay, that's what I was looking at. Okay, March the 18th is good.
Okay. Mr. Turner, March 18th, good for you?
Yes.
Is the AG in your court in person, Your Honor?
No.
Okay.
They're probably on another Zoom.
Okay, they sent their exhibit. I'll just do a new notice. They sent their exhibit, so I know that they were around somewhere. I was just wondering if they were there in person.
Okay. Yeah, sometime they'll pop in, but they're not in here right now. So Joey, let me know when you're ready to go on the record. All right. We're on the record in cause number DF1420778. Counsel, will you please announce for the record?
Jasmine Thompson for Tanisha Jackson.
All right. And Mr. Turner, you're representing yourself. Is that correct?
That is correct.
All right. Will you please raise your right hand? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
All right. We are here set today on an enforcement action brought by your client, Ms. Jackson. Is that correct, Attorney Thompson?
Yes, Your Honor.
And Mr. Turner was notified recently that his attorney withdrew from his case on October 30th of 2023. And as a result of that, there's an agreement to reset this case. Is that correct?
Yes, Your Honor.
All right. Mr. Turner, you are ordered to appear back on this same Zoom, the same Zoom that you used to log in, 688-044-0164 on March 18, 2024 at 9 o'clock a.m. Your failure to appear could result in a habeas warrant being issued for your, a habeas warrant being issued for your arrest. Do you understand that?
Yes.
Okay. Do you have any questions?
No.
All right. So that should give you plenty of time to find an attorney. I just want to make sure that you understand when we come back on March 18th, if you still don't have an attorney, you will have to proceed representing yourself, okay?
Okay.
All right. Is there anything further for the record?
Nothing from us, Your Honor.
All right. Thank you. We're off the record. Thank you all. You're free to leave.
Okay, thank you.
You're welcome. Somebody is logged in. Good morning. The person on their phone, I need you to unmute and turn your camera, well, you're on your phone. You have to be on camera. I'll send you one more prompt, and if you don't respond, I'll just remove you from the courtroom. Right. Okay, next one is at 9:30. Yes. Good morning.
Good morning.
All right.
Good morning.
Good morning. There's someone on a cell phone. I admitted them earlier, but they never identified who they were. I didn't know if they were associated with this case or not, Attorney Plummer.
I'm not really sure either. Because I know we have a contempt thing for this morning, but everyone has been notified and everyone's aware. So my client's here. So one way or the other, everybody was notified to be here at 9:30.
Do you have any not exhibits, witnesses?
Just my client at this time.
Okay. And who is your client?
My client is Torian Stencer.
Okay, Mr. Stencer, and then Miss Pennington, you representing yourself?
Yes, Your Honor.
Okay, and do you have any witnesses that you were calling?
Yes, Your Honor.
What are their names?
One is Shaquoia Strickland,
Okay,
and the other one, it should be LaTanya Twine.
okay, I see. You spell her name for me.
Which one?
LaTanya.
LaTonyatwine.
Okay, I changed her name. I'm admitting her now. It's someone else that was on the cell phone. They wouldn't identify who they were.
Do you know Shaquoia Strickland?
Okay.
Judge Bailey?
Yes.
Ms. Pennington has been aware of this matter and the court's requirements, and she was provided with all of this in the order to appear and in the notice of proceeding and so forth. I request at this point that she be held to the same rules that an attorney would be held to, which provides that if she did not provide any exhibits or witness lists or anything like that in accordance with your ruling, just like I had to, she should not be allowed to present any today.
Okay.
So I have an objection to any witnesses that or anything she intends to present today.
Okay, Ms. Pennington, what's your response?
I don't agree with that, but Your Honor, whatever needs to be done, it's fine with me. Yeah.
Well, let me ask this question. Did you all do initial disclosures?
I haven't done anything ever since I got the email a few months ago. I haven't received anything. I haven't heard anything. I actually reached out to Destiny this morning just to make sure that, because I had the dates, I was thinking that it was tomorrow, and something just told me to look at my email. And so I reached out just to make sure that it was still, going forward today.
Okay. And this is your motion for enforcement, correct, Ms. Pennington?
No, Your Honor, it is mine.
Oh, I'm sorry, Attorney Plummer.
Yes.
It is your client's enforcement.
Yes, Your Honor, for possession and access.
Okay, Ms. Pennington, at any time did you have an attorney?
No, Your Honor.
All right, and you're going to proceed and represent yourself?
Yes, Your Honor. I have nothing to hide. So I don't feel like that I needed an attorney because that's taken away from my child.
Okay. All right. So both sides ready to proceed?
Yes, Your Honor.
Okay. And Attorney Plummer, you can make your objection on the record once we go on the record, okay?
Okay.
All right. We're on the record in cause number DF 1500398. Counsel, will you please announce for the record?
Natalie Plummer representing the petitioner Torian Stencer.
All right. And Ms. Pennington, you are the respondent in this matter. Is that correct?
Yes, Your Honor.
And you submitted to the court that you will be representing yourself. Is that also correct?
Yes, Your Honor.
Okay. And Attorney Plummer, you had an objection you wanted to make?
Yes, Your Honor. I object to the admission of any witnesses offered on behalf by the respondent, any evidence that she hopes to introduce today on the basis that she is to be treated as an attorney since she's representing herself pro se. She should be held to the same rules that any attorney would be, especially with regards to the court's policies and procedures, specifically that she was required to file any exhibits earlier before now, as well as any witness or exhibit list. Or any witness list. And so I object to any witnesses or any documents or evidence that she intends to introduce.
Okay, Ms. Pennington, do you understand her objection?
I don't understand it, but she's gonna, depot herself through it anyway. So that's fine, Your Honor.
Okay, well, I was going to explain it to you. And a motion for enforcement is considered a final trial.
Mhm.
And anytime you come before a final trial, there are rules that you have to comply with, not just necessarily the court's rules, they're statutory, based on
Okay.
what the state of Texas rules say about any presentation of witnesses as well as exhibits that you're going to use. So essentially, the law allows me to exclude evidence if they're not proper before the court, meaning you didn't follow the rules. So at this time, I would be granting her objection.
That's okay.
Okay.
Mhm.
All right.
I
So,
provided evidence last time, but no one never presented them, but it's fine.
well, when you mean when you emailed them to Destiny?
To the court, yes. And I went up there to the office as well.
Okay, so let me explain that to you.
Okay.
Because you are representing yourself, you're held to the same standard as anyone else.
Mhm.
As an attorney as well. So when you submit evidence, you're not actually putting on that evidence to the court. You actually have to introduce it. By virtue of sending it, I can't even take it into consideration unless it's presented to.
Okay.
Does that make sense?
Yes, Your Honor.
Okay, so this is what I'm going to do. Ms. Twine, thank you for your time, but it doesn't look like we'll be needing any testimony from you today, okay? Thank you. Let me set you all. And this is a 30-minute hearing. You all have 15 minutes per side. Attorney Plummer.
Yes, Your Honor.
Hold on. I'm speaking out loud and typing your name at the same time. I'm setting you all's clocks. So, Ms. Pennington,
Yes, Your Honor.
within this 15 minutes, this will include any opening statement, should you choose to make one. You don't have to make one if you don't want to. It'll also include any closing statement you would like to give to the court, as well as any direct or cross-examination. So you do have the opportunity once Mr. Spencer, once Attorney Plummer passes him, that's your opportunity to ask some questions based on his testimony. Now, Attorney Plummer has the right to object. So if your questions are not proper or legal within his testimony, right, she has the right to object. So I just want to make sure that you understand that, just like you have the right to object to any questions that she may ask of her client, just know that if it's not a legal objection, I can't entertain it.
Okay.
Okay.
Yes, Your Honor.
All right. So you all are set at 15 minutes aside. Attorney Plummer, would you like to give an opening statement?
Yes, Your Honor.
Okay, you may proceed.
On January 27th, 2015, the court entered a child support review order establishing the parent-child relationship in this matter between the Torian Spencer and Dewana Pennington regarding the female child, Skylar Pennington, born July 15th, 2014. They were granted joint conservatorship and rights and were established as far as visitation in that order. As a result of this, Ms. Pennington has chosen not to follow this order and has violated the court's order at various times. Specifically, she failed to, I should say, follow the court's order to allow my client his Wednesday weekends, first, third, and fifth weekends, his Thursday, Christmas, and November for Thanksgiving vacations for the child. She's been denying him access to the child for her birthday. She failed to provide my client, in accordance with the order, the notice of her change of address, notice of change of her employment or work number, and to date had not actually followed the court's order to provide any of this information, therefore denying my client the opportunity to exercise his rights. We are requesting at this point, we're moving forward with a contempt, and we are wanting, and that's where we are, why we're here today.
Thank you. All right. would both sides raise their hand, their right hand? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
I do, Your Honor.
Yes, I do.
Thank you. You may lower your hands. Ms. Pennington, at this time, if you would like to give an opening statement, you may.
Your Honor, so I put Torin, Mrs. Spencer, on child support back in, I think it was back in September of 2014. She was born in July, but I didn't do it until September because I was advised by someone that he was throwing parties, doing everything else.
Objection, Your Honor. She's giving a narrative.
Hold on one second, Ms. Pennington. Go ahead, Attorney Plummer.
Objection as to narrative. And she's giving testimony versus an opening statement.
Sustained. So, Ms. Pennington, once it's your opportunity to speak in terms of responding to the allegations against you, that's when you will.
Yes, Your Honor. I wasn't going into deep. I was just telling, starting it out. But let
me like streamline this a little bit for you. On opening statement, you're pretty much telling what the evidence is going to show or what the evidence is not going to show. So you're being accused of violating the order. So that's how you would kind of respond in an opening statement. It doesn't have to be, anything long and where you're defending yourself, right?
Okay.
You do that when it's time for examination.
Okay. So I've never denied Torin his rights. Basically, he's denied himself. I've never denied his rights. I have allowed him to get his child. I have text messages for him getting his child. I can't deny you. I went years without reaching out to him, trying to see what works best for him.
Objection, Your Honor, testimony.
That's all I can say, Your Honor. I've never denied him his rights. Never.
Okay. Thank you, Ms. Pennington. Attorney Plummer, you may call your first witness.
Thank you, Your Honor. I call my client, Torian Spencer.
Okay, Mrs. Spencer, would you please remove yourself off of mute?
Yes.
Okay, Attorney Plummer, you may proceed.
Mr. Spencer, were you part of a hearing which resulted in an order on January 27th, 2015 before the Attorney General's Court?
Yes.
And in that hearing, were you granted rights?
Yes.
And were those rights specifically addressing weekends?
Yes.
Were you granted first, third, and fifth weekend of each month?
Yes.
And were you allowed to have your first, third, and fifth weekend of each month?
No.
Okay. Let's start with the order. Let's go in order. Were you given specifically Thursdays?
Yes.
Were you given Thursdays from 6 to 8 p.m.?
Yes.
And specifically on the Thursdays that are listed in the motion for enforcement, in the interest of moving forward with this case in a manner that can be handled quickly for the court, do you believe that you were denied access on Thursdays starting in November of 2022?
Yes.
Okay, and you were denied. So I'm going to go through them very quickly. So I just wanted to make sure that we list all of them so that the court can consider them. Okay.
Yeah.
All right. Were you denied access on Thursday, November 10th, 2022?
Yes.
On Thursday, November 17th, 2022?
Yes.
On December 1st, 2022?
Yes.
December 8th, 2022?
Yes.
December 15th, 2022?
Yes.
January 5th, 2023?
Yes.
January 12th, 2023?
Yes.
January 19th, 2023?
Yes.
January 26th, 2023?
Yes.
February 2nd, 2023?
Yes.
February 9th, 2023?
Yes.
February 16th, 2023?
Yes.
February 23rd, 2023?
Yes.
March 9th, 2023?
Yes.
March 23rd, 2023?
Yes.
March 30th, 2023?
Yes.
April 6th, 2023?
Yes.
And then I'm gonna do these quickly. April 13th, April 20th, April 27th of 2023.
Yes.
May 4th, May 11th, May 18th, and May 25th of 2023.
Yes.
August 10th, 17th, 24th, and 31st of 2023.
Yes.
September 7th, 14th, 21st, 28th of 2023.
Yes.
October 5th, 12th, 19th, and 26th of 2023.
Yes.
November 2nd, 9th, and 16th, and 30th of 2023.
Yes.
December 7th, 2023.
Yes.
When you attempted to exercise your visitations with Ms. Pennington, were you given an excuse?
Yes.
Were they excuses that prevented you from being able to see your child between the hours of 6 and 8 p.m. on Thursdays?
Yes.
Were there instances where you attempted to reach her by phone and were not able to do so?
Yes.
You were denied your visitations on Thursdays. Is that your understanding?
Yes.
Let's deal with your weekend violations. Were you denied access on November 18th, the third Friday of the month of 2022?
Yes.
Were you denied access for your child for the first Friday of the month of December on December 2nd, 2022?
Yes.
Were you denied access to your child at 6 p.m. on Friday, December 16th, of 2022, which was the third Friday of that month?
Yes.
Were you denied access to your child on the first Friday of the month of January, which was January 6th, 2023?
Yes.
Were you denied access to your child on the third Friday of January on January 20th, 2023?
Yes.
Were you denied access to your child on Friday, February the 3rd, 2023?
Yes.
Were you denied access to your child on February the 17th, 2023?
Yes.
Were you denied access to your child on the first Friday of the month on Friday, March 3rd, 2023?
Yes.
Were you denied access to your child on Friday, March 31st, 2023, which was the fifth Friday?
Yes.
Were you denied access to your child on the first Friday on April 7th, 2023?
Yes.
Were you denied access to your child on Friday, April 21st, 2023, which is the third Friday of the month?
Yes.
Were you denied access to your child on March the 5th, 2023, which was a first Friday?
Yes.
Were you denied access to your child on Friday, May 19th, which was a third Friday of the month?
Yes.
Were you denied access to your child on Friday, June 2nd, 2023, which was a first Friday of the month?
Yes.
Were you denied access to your child on June 30th, 2023, which was the first Friday of the month?
Yes.
Were you denied access to your child on Friday, July 7th, which was the first Friday of the month of 2023?
Yes.
Were you denied access to your child on the first Friday of the month, Friday, August the 4th, 2023?
Yes.
Were you denied access to your child on the third Friday of the month, August 18th, 2023?
Yes.
Were you denied access to your child on Friday, September the 1st, 2023, which was the first Friday?
Yes.
Were you denied access to your child on the third Friday, on Friday, September the 15th, 2023?
Yes.
Were you denied access to your child on the fifth Friday, being September 29th, 2023?
Yes.
Were you denied your child on the fifth Friday of the month at 6 p.m. on October 20th, 2023?
Yes.
Were you denied your child on the first Friday, on Friday, December the 1st, 2023?
Yes.
And were you denied your child for your Christmas vacation period of this year, which from 6 p.m. for possession of your child?
Yes.
Of 2022, I'm sorry.
Yes.
All right. Were you denied Father's Day visitation for this year on June 16th?
Yes.
All right. Were you denied your summer possession, which you're entitled to by law, in the month of July of 2023?
Yes.
Were you allowed to see your child on her birthday, July 15th, 2023?
No, not for the full time, no.
Were you able to see the child for the entire period from 6 p.m. to 8 p.m.?
No, I was
And
able to give a gift and leave.
Were you allowed to exercise your court-ordered visitation at the residence of Duana Pennington?
No,
Okay. Let me move forward. Did she violate the possession and access order by failing to provide you with the name of your child's new school and address?
yes,
And did that deny you your right to be able to begin your period of access at the time the child's school is regularly dismissed?
yes,
Now, she violated the court order and other statutory violations as well. Is that correct?
yes,
Did she fail to notify you of her change of employer on or before the 60th day before the expected change, or that she was required to give the information?
yes, she failed to do so.
Did she also fail to provide that information to you at any point to date?
Yes, she failed to do so.
In fact, in a hearing before this court in July, did she not refuse to provide her address information, even when the court made it clear that she was required to give it to me?
Yes,
Did she provide you with a notice of her new work phone number on or before the 60th day of the expected change of that information?
no, she did not.
As to date, has she given you her work phone number?
No,
Okay. Did she provide, to your knowledge, did she provide any of this information to the court or the court registry of her change of address, her change of employer, or her change of work phone number?
no, she has not provided it.
Now, you have a right to be notified of all of these things. Is that correct?
Yes,
And in the court order that was entered on July the 15th, July 27th, 2015, she specifically was required to make sure that you were given this information if she changed the school of the child that was enrolled for the 2023-24 school year. Is that right?
yes,
And provide you with name and address. She didn't give you any of that information, did she?
no,
Did she even attempt to confer with you with regards to changing the school?
no,
So you were denied that right as well.
yes,
Did she give you the attempt to confer with you before she made a decision concerning the health, educational, welfare of your child?
no,
Did she fail to confer or attempt to confer with you prior to doing any of these things?
yes, she failed to do so.
Did she designate you as a person to be notified in the case of an emergency on the child's school records?
No,
At this point, there's a lot of violations that we've discussed. Did she give any good reason as to why she denied the court's order?
no good reason, not according to the law.
Did she actually block your phone number for a period?
Yes,
And did she deny you access to your child for these reasons?
yes. She actually even blocked me on the tablet that I bought my daughter so I can be able to communicate with her.
You had Thanksgiving this year, is that correct?
Yes,
And you were denied your child during that period, is that correct?
yes,
Did she actually let you have your daughter and then later refuse to return your daughter to you?
that is correct.
Are you seeking to put your child's mother in jail today?
Honestly, no.
Would you be satisfied with the court placing her on probation so that she is required to report to a community supervision officer and required to follow the court order from this point forward or face jail time?
Yes, I just need some type of accountability.
Have you incurred attorney fees with regards to all of this to pursue this entire matter?
Yes.
And are you requesting that, have you incurred attorney fees in the amount of at least $11,246.12 in order to, with all the various communications of violations and everything since this matter was filed in the summer?
Yes.
And you had to incur costs for a process server, is that correct?
Yes.
And you believe that the court should reimburse you for all of your costs and expenses associated with this matter, is that true?
Yes.
Do you believe that this is in the best interest of your daughter?
Yes.
Do you want to spend time with your child?
Most definitely. Uninterrupted time.
I'll pass the witness at this time, Your Honor.
Okay, and counsel, you just ran out of time. Ms. Pennington, do you have any questions for Mr. Stencer based on his testimony?
Oh, yes, Your Honor.
You may proceed.
Mr. Stencer, before November 2022, have you ever been denied access to your daughter?
Yes.
Before November the 22nd, November the 22nd, 2022, the reason why you didn't have access of your daughter, was it because you tried to put a fake assault case on me?
It wasn't a fake assault case. You actually came to my house.
I asked you.
I'm answering the question.
Okay.
You tried to force yourself into my home, and you actually took my daughter, which was during the time period that I was supposed to have her, according to the order.
Okay,
and you
Mr. Stencer.
assaulted me in the process, as well as went around to my backyard, tried to force yourself into my home, and this was in front of our children as well as my stepchildren.
Your stepchildren okay, never mind. Okay, before then, Mr. Stencer, since you said that, on November the 5th, when that took place, that was on a Saturday, correct?
Yes.
On November the 4th, which was a Friday, did you come and get possession of your child?
No, my mother did.
No, correct. So before November the 4th, 2022, have your child, no, I'll take that back. Hold on, let me go to before November the 20th, so November the 4th, 2022, why didn't you come and get your child per your court orders? I
would try. Most of the time, I did not try to deal directly with you because of your aggressive behavior and because you're very confrontational. I even tried to do a communication setup to where it was you, myself, as well as my mother on a text thread, because with you and I being by ourselves, it just wasn't working. Every time I said or did anything, then I'm wrong. And so I felt like I needed some type of other accountability piece to be able to at least try to have some order for me to be able to get to my daughter.
This is just beyond me. Mr. Stencer, before.
Hold on 1 second, Ms. Pennington. Counsel, what's your objection?
My objection is to the extra antics and attitude being thrown out by Ms. Pennington with her response to my client's testimony.
Sustain as to sidebar. Ms. Pennington, after you ask your questions, you can't then turn around and make comments afterward. Okay.
Okay. Mr. Stencer, before November 2022, last year,
Your Honor, irrelevant as to the time frame in
you
this.
won't even let me ask the question, ma'am. I'm trying to ask the question.
Hold on. Finish answering your question, and then Attorney Plummer, you make the objection. Go ahead, Ms. Pennington.
So as of November 2022, how many times did your daughter spend the night at your house before November 2022?
Actually,
Objection, Your Honor, irrelevant as to my client has a right to the possession, whether he exercises it or not. He attempted to, this order is with regards to information, the violation that took place after November 5th, 2022. Anything before that date is irrelevant.
Sustain. So the dates that we're working with, Ms. Penny, according to the motion, okay, I don't see a date in here for November 5th. The dates that I see start November the 10th of 2022, and they go all the way through, looks like August of 2023. So those are the dates that we're working with.
Yes, okay. So nothing before matters that he didn't do what he's supposed to do before. So just now because he's trying to, okay.
Objection, sidebar.
No, I think she was asking overall, I think she was asking a question. So
yes, so nothing before November the 10th of 22 matters.
and I actually want to
hold on, Mr. Spencer, hold on. I think she's asking me the question.
Yes.
It matters in the sense of if you're trying to show a history, but the actual dates that they're talking about are November the 10th, starts at November 10th, 2022. So I can't tell you how to put on your case. I can just tell you, if you want to stay on track and avoid the objections that she's making, work with each one of those dates that he listed in his motion. Do you have the dates?
So November started November the 10th until August 23rd. The reason why you didn't see your child is because, well, I'm gonna take that back. August 23rd, I think that's what you said. After August 23rd, which was the end of the fake assault case you tried to put on me, you started
Your Honor.
Start seeing your child, correct?
Objection, Your Honor, objection as to assuming evidence. There is nothing has been shown that there was a fake assault charge.
I got the dismissal. I guess I need to find the documents for the dismissal.
If you would just rephrase it instead of saying a fake charge, you can say it was dismissed. So
from November the 10th, 2022 until August 2023, you weren't able to see your child because of the alleged assault case, correct?
I was not able to see her because you denied my access. And this actually started before this. But that was, I guess, the
objection, Your Honor. Objection. We stated the dates, right? We stated November the 10th until August 23rd, correct? So nothing else before that basically matters, right?
Well, I didn't say it didn't matter. It's the way that you have to use it. If you're trying to use it to show a history of him not showing up, that's one thing. Not necessarily specific dates, but just, in the past not showing up. But what I'm saying is in terms of the violations, the only violations that they have on here start November 10th, 2022. And the last one, I said August the 23rd. I meant August the 10th of 2023. Those are the actual dates that you should be asking him questions about. That's why I asked you if you had a copy of the motion, you can go date by date.
Okay. No, I don't have a copy of the motions. But
hold on one second. Attorney Plummer, would you mind sharing your screen and pulling up the motion so she can actually work with the dates? And then you can ask him specifically, you can look at the violation and ask him specifically about each date, okay?
Okay.
That'll help you with defending your case, and it'll keep you from running out of time too, if you have the motion in front of you.
Okay. So,
excuse me, Your Honor, I would like to point out that not only was she provided a copy by the court coordinator when she decided to, when she participated in the selection of the first hearing that was set, she also has been personally served with this motion, as well as the order to be here today. So she should have access, but I have no problem sharing my screen. Hold on just a moment while I try to figure that out.
The last court, but I think I have it over here.
Okay, can you see it?
Yes, ma'am. Thank you. Could you zoom in a little bit?
Hold on, I'm about to see if I can widen the screen. There we go. All
Miss
right.
Pennington, she pulled it up on the screen for you.
Okay, I went and got it too.
Okay, all right. So if you start on page 5, I think.
Yes, page 5 deals with the Thursday violations. Page 4 starts with some of the rights that were violated in the court order.
Yes, if you wanted to start at the bottom of page 4, Ms. Pennington, and ask him questions based on each one of those violations. That will probably be more helpful. Attorney Plummer, thank you for sharing your screen. You can stop sharing it. She has the paper in front of her now.
Thank you.
I think I do. It's a lot, Your Honor. She could have kept it up further, but it's fine. Before the November the 10th. I'm sorry, we can't even go before November the 10th, huh? Yeah. Again, I've never denied you.
Hold on. He's on the witness stand, so you have to ask him questions unless you're done asking him questions. Did you get the motion so you can see the allegations?
You know, I work 2 jobs. Let me tell you, this is beyond me. Too much of my time. Just got off work this morning. Again, before November the 10th, have I ever denied you possession of your child?
Yes.
Okay.
When you have plans for her, even if it's my time, then you think that your plans supersede my time, which is according to the order.
So I asked, for November, for Thanksgiving, did you not receive your daughter on that Friday?
Objection, Your Honor. As to vagueness, she needs to specify the year she's referring to.
2020, what's this, 3? Did you receive your daughter?
Yes.
Did your daughter?
And I actually received.
Hold on. Y'all can't speak at the same time. My court reporter can't get what both of you are saying. I believe the question was, and I don't think I even addressed the objection. It was sustained, and Ms. Pennington clarified her question for 2023. I didn't catch your question at all, Ms. Pennington, because the two of you started speaking at the same time. So ask your question again.
I asked him before, did he receive his daughter for November the 17th for Thanksgiving on that Friday?
And my answer to that is the only reason I was able to get my daughter is because I've been communicating with her directly and through her aunt, who's actually trying to do what she's supposed to be doing, which is allowing me to access my daughter. It wasn't through you.
How do you think that how you get her? Oh, okay. So, Your Honor, your daughter reached out to you, correct, Torin?
Yeah, I actually reached out to her and she reaches out to me as well.
Correct, because you send, do you not send me an email regarding your weekend possessions now?
Yes.
You just started sending me emails, correct?
Mm-hmm.
So when you send me emails, I let your daughter know to reach out to you so you all can talk. Correct. So your
Objection as to speculation. Objection as to speculation, Your Honor. He can't know what she did or did not do.
Your daughter not reach you, contact you on your tablet.
Ms. Pennington, hold on. She's giving the objection and she has to state it for record keeping purposes. Counsel, I see objection to speculation sustained. Ms. Pennington, ask him questions that will be within his knowledge, not necessarily where you're asking him to speculate. Because if he doesn't necessarily know, you're going to always get that objection from his attorney.
Okay. Did your daughter let you know that she wanted to go and spend time with her friends during Thanksgiving break?
Yes.
When you contacted your daughter on Thanksgiving to ask your daughter about the time that you wanted to come get her, did your daughter not tell you that she didn't want to go?
After you took her in your possession and she was actually supposed to be at her aunt's house, yes, she did make that statement while she was in your possession, which she wasn't supposed to be. And I actually reached out to you that same day because I know that as a kid, she shouldn't have that decision, because especially with us having a court order, and you still denied my access.
Yes, I did. Well, I did deny. I'm say this because I don't want my child to be uncomfortable.
She's never been uncomfortable.
She let me know. Right hand to
Objection, Your Honor, hearsay.
again. I don't.
Ms. Pennington, ask him questions, not argument. When it's your turn to speak, then you can speak freely, but ask him questions, okay?
Okay. Okay. So your daughter reached out to you and told you that she didn't want to come over there, correct? Via her tablet. She didn't want to come back.
Objection as to time frame.
November.
Sustain. Which day are you talking about, Ms. Pennington?
Let me pull up whenever Thanksgiving was the what, 24th, 23rd this year, 2023?
Yes.
So your daughter, correct?
Under your possession, yes.
To allow this app to make changes. I'm sorry, hold on, Your Honor, something popped up on my thing, it took away. Okay. Okay. Something popped up on my computer and took it away. That's Your Honor. I honestly don't have no more words for this man.
Okay. All right. So Attorney Plummer, you're out of time. Ms. Pennington, this is your opportunity to tell the court whatever you want the court to know. Just know that anything you say can be used against you, okay? And although Attorney Plummer is out of time and can't ask you any questions, I can ask you questions based on your testimony, okay?
Okay, and this has to be regarding November this last year to now, right?
Yes, ma'am. So all of these allegations, like I said, you are defending yourself against each one of them. I just want to be clear though, on an enforcement, he doesn't have to prove that you violated each one of them. All it takes is one to pop you, okay? All it takes is one violation. So out of all these violations, if the court finds that you violated at least one of them, you can be held in contempt, okay? So I just want to make sure that you understand that part. And the dates that we're working with are November 10th, 2022 through October the 10th of 2023. Those are Thursdays as well as first, third, and fifth weekends. He's also alleging violations of you not providing the school information when you allegedly enrolled the child in a new school, concerning your address, not turning over information about your work address as well as your home address. So all of those allegations is what he is alleging. So in your testimony, you're free to defend yourself on each one of those allegations.
Okay.
Okay, go ahead.
So again, I've never denied you any type of rights to Skylar.
Objection, Your Honor, to speaking to my client directly.
How do I speak? Do I just talk and say
to me? You're talking to me.
Okay, Your Honor. I've never denied Torin rights, and that's right. I have no reason to lie. That's right hand to God. Every time Skylar's been in school, honestly, he has been on the school documents, but Torin has not reached out to see about homework. Torin has not reached out to see about her STAR test. The last year was the first time Skylar has ever spent the night at Mr. Stencer's home. Mr. Stencer has a home that he's never made a home for Skylar. She's never had any type of—
Objection, Your Honor, testimony.
Well, this is her statement. She can give testimony.
She's never had a room at Mr. Stencer's home.
Objection, Your Honor, irrelevant. How would she know what if she's never been inside his home?
Because my daughter lets me know. Skylar, me and Skylar.
And you can't tell me what the child said. That's hearsay.
Okay.
Just speak to, as I said, that's why I said, if you have the motion in front of you, it's easier if you have it, so you can stick to the violations.
Skylar went over during Thanksgiving break. Skylar is used to going with her friends and family on Thanksgiving breaks. Skylar wanted to make cakes and pies with her friends. She went over there. Skylar came back. She knew she had to go over her dad's house. I let her know, you got to go back over your dad's house. She came to me Thanksgiving and said, Mama—
Objection, hearsay.
Sustain. You can't tell me what the child said.
Okay, well, she didn't want to go back. So I advised her, reach out to your dad and you let your dad know. At the end of the day, Your Honor, my child has never, I'm going to say it, Your Honor, I'm not going to force her to go over somewhere to stay 10 days when she's barely stayed 3. And that's throughout, since she's been 9. Skylar has never spent the night at his house but one time last year. Skylar doesn't feel like his home is her
Objection,
home.
Your Honor, speculation.
Okay, well, my child has her own room here. She has her own toys here. She doesn't have to share rooms, or she doesn't have to sleep on futons.
Objection, Your Honor, speculation and
There's no
irrelevant.
speculation, Your Honor. My baby FaceTime
argumentative.
me. My daughter has FaceTime me, and I have seen the conditions. And that's the God honest truth. My daughter is loved by her granny, by his mom. Absolutely. Anywhere she has had a residence, she has made Skylar have a home, have a room. All of Skylar toys is at his mom's house. Everything that Skylar loves her granny. That's off top.
Objection, Your Honor. This is getting off point.
Just honestly let you know, Your Honor. Again, right hand to God, I've never denied. I've always been there. I have reached out to Mr. Spencer and asked him about the relationship with his daughter. How can we a relationship? He has denied me. He has told me to go to
you just ran out of time.
Okay, that's fine.
Ran out of time. Okay, I have a question. A couple of questions for you, Ms. Pennington. Did you enroll the child in a new school?
Because
no, hold on.
New school for the last year.
Hold on.
In new school.
The questions, I just want yes or no.
Yes.
Did you enroll the child in a new school?
Yes.
Did you let him know that you enrolled the child in a new school?
No, I didn't let him know last year.
Okay.
He never wanted to know.
Okay. So, home address, does he know where you live?
Yes, he's always known where I live for over the 5 years. Nothing has changed.
Objection.
What's your objection, counsel?
Objection as to the question was, did she notify him of the address? And her answer is, he knows. That's not the same thing.
Well, I actually didn't ask the question right. I need to rephrase it because I asked, does she know where he lived? Let me ask the better question. Did you notify him that you were changing your address?
My address been the same, Your Honor.
No, it's not.
When you changed your address 5 years ago, did you notify him?
He's been over here, Your Honor. Yes.
That wasn't my question. Did you notify him? Okay.
He had to come get her. He had to come see her. So he was notified.
Yeah, I only got the information through my mother.
Because you advised me to go through your mother. But
hold on. You all do not have to talk to each other right now.
I got a sticky note over his face, Your Honor. I don't even want to see that man.
Oh, okay. Miss Pennington, that's not necessary.
Just saying.
Did you recently change your job?
It's been a year.
Okay. Did you notify the court of your change of address at your job?
No.
All right. I'm just going through their motion, asking you. I didn't hear testimony on this.
Yes, Your Honor, he gave testimony on that. Do you have a copy of the order?
Oh, I'm saying from her. I heard his testimony. I didn't get her testimony. Okay. Someone just came into the courtroom. You all give me a few minutes, okay? Hold on.
Okay, Your Honor.
Okay. All right, so no, not yet. So before I make my ruling, I want to give you all an opportunity to be put in a breakout room to see if you all can come to an agreement, if any. I think that'll help both sides. If that's something you all would be interested in doing.
Who in to go in the breakout room, Your Honor?
All three of you. He can't go by himself because he's represented by an attorney. So the three of you would have to go in the breakout room and speak to see if you all can come to some sort of an agreement based on the allegations that are mentioned in the motion.
I'm not going in a breakout room if she don't allow me to speak. I'm just letting you know that. I'm not
Okay,
trying.
both of you have to allow each other to speak, all right? And that's not me giving a recommendation. You're not letting me speak.
I'm sorry, Your Honor. She disrespectful.
Okay, you're being disrespectful to me, and I'm just trying to. Okay, so this is what I need you all to do, and this is actually in order. You all are going to go in the breakout room. You're going to have a conversation to see if you all can come to some sort of an agreement about this motion, and that's everything. The allegations, attorney's fees, like you all need to have a legit conversation, okay? So I'm going to put you all in the breakout room. And when you all, when you're done, just come back in to the main room, okay?
May I make a request, Your Honor?
Yes.
I'd like to make a request that the court take judicial notice of the order enforcing the possession and access order that was filed with the court, so that because we ran out of time we were limited in order to introduce additional periods of access and so forth. And I'd like the court to take a judicial notice of that information and incorporate it herein.
Okay, the court takes judicial notice of all contents of the court's file.
Thank you.
You're welcome. You all, the breakout room is open now, so go ahead and go to the breakout room.
Okay, thank you.
You're welcome.
So definitely be more convenient via Zoom. I have my tablets, I could set up at council table, but I was hoping that she and I would be able to visit this morning.
You and Attorney Holland? I think it may be easier for you to get on Zoom, and that way I can put you all in a breakout room. Okay. Let me admit her.
Grab one of the conference rooms.
Yeah.
That way there may not be feedback.
Exactly. So I'm going to open up a second breakout room. Good morning.
Good morning. How are you?
Good. How are you doing?
I'm okay. The weather's doing a number on my head. And your blouse looks really good on Zoom. It's so pretty.
Thank you. Thank you. So I have counsel here, and he's in person. So he's going to go to our conference room and set up, and that way I'll put you all in the breakout room so you all can have an opportunity to speak.
Okay. All right. Thank you.
You're welcome.
Should I grab that so I can talk to her?
Sure. There you go.
Appreciate you, John.
All right. Attorney Holland, do you have someone named Cynthia White?
No.
Okay.
I represent Antonio Zepeda.
Okay. Let me open these breakout rooms back up.
Thank you.
You're welcome.
Good morning.
Who said that? Hi. Which case are you here on?
I'm actually just here to get sworn in as a new attorney.
That's right. That's right. Let's do it.
Congratulations.
Thank you.
Congratulations. Welcome aboard.
Okay, I'm assigning you all to rooms now. All right. Let's see. Is that Mr. Zepeda on the iPad?
Yes, Your Honor, it is. I think he's muted right now.
Okay. All right, and Mr. Zepeda, you're getting ready to receive a note to move over. Sign to room 3. And I think that should take care of everybody. All right, Ms. White, Would you happen to have emailed your oath?
Like what it has to, what I have to say.
Yes.
I have it up here.
Could you email it to Joey because I can't see it?
Okay. Can I send it in? Is there a chat? Yeah. Can I send the link in the chat?
That may work. Go ahead and let's try that.
Okay.
All right, I've got it. Yeah. Okay, are you excited?
Yeah.
Okay, are you interested in any particular area of law?
Well, I have a job. Well, I'll be starting a job as a family attorney in Tennessee.
Okay, congratulations. Congratulations. So, raise your right hand and repeat after me. I state your name.
I, Cynthia White,
Do solemnly swear that I will support the constitutions of the United States
do solemnly swear that I will support the constitutions of the United States
and of this state,
and of this state,
that I will honestly demean myself in the practice of law,
that I will honestly demean myself in the practice of law,
that I would discharge my duties to my clients to the best of my ability,
that I will discharge my duties to my clients to the best of my ability,
and that I will conduct myself with integrity
and that I will conduct myself with integrity
and civility in dealing and communicating with the court
and civility in dealing with and communicating with the court
and all parties.
and all parties.
So help me God.
So help me God.
Congratulations.
Thank you so much.
You're welcome. You're welcome. So I will get this signed and sent back over to you, and then you'll sign it.
Okay.
Okay. Congratulations again.
Yeah. Have a good evening.
You're welcome. And I just want to let you know too, we stream live on YouTube. So everyone who's watching our YouTube channel also was able to see you get sworn in. So it's pretty cool.
Okay. All right.
All right. Have a good day.
Bye.
Bye-bye. Who is not assigned to a breakout room? Did you get the?
Oh, yeah, we're in the breakout room, but so is her client. So
Oh.
there's a way that you can.
Yes, I'll move him back to the waiting room. No worries. How are you all doing? Good, good. Are you all here with the attorneys? Okay. Okay, okay. I figured that. Let's see. All right, Mr. Zapata, I'm going to place you in the waiting room, okay? All right. Today is the 12th or 11th. 11. I'm going to step off really quick. If you hear him, just let me know. All right, we're back on the record. Okay, we're back on the record. So the court ordered you all to go into a breakout room to speak, and it's the court's understanding that it just didn't work. You all couldn't come to any sort of resolution.
Just like I told them,
well, you don't have to tell me those are settlement negotiations.
Well, I can meet them at QT. Well, my auntie can meet them at QT. She asked about that. I said, there's no problem. She wanted to know about any additional days that he didn't get her or whatever, just like I advised. I have no problem with that. I will let Skylar know that. But, and my daughter's 9. She's not 8. She's 9, gonna be 10. And that's it. And I agreed to no, I'm not about to pay for something that no, Your Honor.
Okay, and I respect that. I at least, appreciate you all attempting to do it, right? That was a big step. The reason why, well, let me say this before I give my ruling. A child cannot say who they want to go with. They can never say that. Skylar cannot say when she's at daddy's house, I don't want to go back to my mama's house, and dad not turn her over. It doesn't work like that. Same thing with you. If she says she doesn't want to go with dad, you still have to turn her over to dad, because the court order is between the two of you, and you still have to follow it. There is a thing called passive denial. So if the child say they don't want to go, you're not actively telling the child they don't have to go or they can't go, but you are passively denying possession and access. And that could bring you right back here again, Ms. Pennington. And I know you don't want to be here. So,
baby, Judge, I will. For my baby, I will.
Okay.
And that's not honest truth.
Okay, so I just want both of you to understand that you have to follow the court order, what it says. Now, if you all agree to exchange at QT, that is your agreement. However, this court order does not say that. So if absent an agreement, you all default to the order. Something else I wanted to make sure is clear. You all can send any competent adult to exchange your kids. It says it in your court order. You can send an aunt, uncle, boyfriend, best friend, whoever is considered a competent adult. They can do the exchanges, so you all do not have to deal with each other. I just want to make sure you both understood that you have the right to do that. All right. Okay. Now that's my admonishment for the in terms of following the order. Now, on the motion for enforcement, it is a very technical motion. And according to section 157.002 of the family code, I'm not able to hold her in contempt. The violations are not specific enough contained in the motion to actually hold her in contempt. And because no testimony was put on about attorney's fees and the expenses, I can't even award that.
Your Honor, we weren't given, I didn't have enough time to do that, to go through all of her 80-something violations and get to the attorney fees, but my client did specifically state that he did incur $11,246.12 for process service and in payment of attorney fees. So that part would at least got in. And in the order,
that made it in, but you have to put on the testimony for the attorney's fees. Like, you have to call yourself as a witness and actually put on testimony for that. I just can't award it because it made it in the record. Like, I actually have to hear the testimony from you to prove up those fees. And in regards to the actual violations, they have to be specific: date, time, manner. My review of the record was, you asked him, did she deny? And he said yes. That's not how you prove up an allegation on a motion for enforcement. You actually have to go through each one. Well, you don't even have to go through all of them if you choose not to, but you have to. It's twofold on an enforcement. You can't only show that she violated, you also have to show that your client was in compliance with it. They're very technical motions, and
Well, Your Honor,
my
I
hands are
tried
tied.
to, but we ran out, you cut off my time. I didn't get a chance to go for it. He did explain that he was denied all of them because she gave excuses for why she would not allow the visitations. And other times she just didn't answer his calls. He stated that on the record. There was testimony with regards to that. And if the court would allow, I'd be more than happy to go ahead and prove up my attorney fees, because this was ongoing violations even after she was made aware of the motion and provided a copy of it via email, as well as later served personally.
And counsel, I understand what you're saying. However, the way he has to be asked a little bit more on a motion for enforcement in order for me to do anything. Statutorily, the chapter 157 does not allow me to award any makeup time, holder in contempt, or anything based on the questions that were asked. And the motion itself is defective. It has to be very specific. Otherwise, I can't do anything pursuant to what the law says. That's not me. That's what the law actually says.
Your Honor, I'm confused as to why it's not correct, because it gives the actual date. It gives the it says the first, third, or fifth Friday. It specifies Thursdays. It says the child was not made available at all on those dates. Is provided in the motion. It gives all of that and precedes it by quoting the actual order that provides for the violations. I followed everything that's in there. Where is it that you state that it is not, that it is somehow defective? Because I provided everything in the order specific as to the wording.
Well,
and this is,
go ahead.
So I'm confused as to how is it defective? Because it provides everything that I was required to provide.
Okay, one, you failed to comply by surrendering the child. You actually, in your violation, you have to show what took place. Like, did he send her? So it's twofold. Like I said, you have to show that she actually violated, but you also have to show what he did to be in compliance with it. The court didn't hear any testimony or anything to say that he was there at 6 o'clock. It doesn't state the manner, the location where you're supposed to trade. Exchange, it says Deanna Pennington failed to comply by surrendering the child to Torian Spencer on Thursday, January 26, 2023. The child was not made available. The child was never identified. There's no name of the child in the motion, which that's fatal, as well as it didn't state the location. Like, what does the order say they're supposed to exchange? That has to be in the actual violation in order to comply with the rules in ex parte Slavin.
Okay, because it specifically names the child of the suit.
Right, but you have to do it in every violation. Every violation. According to ex parte Slavin, you actually have to track the language of the order. So how you wrote out the language there, you'd have had to do that exact same thing on each one of the violations in order to hold her in contempt. Otherwise, the law doesn't allow me to hold her in contempt. And if it's defective, I mean, I can't do anything with that.
But that's how the actual 2015 order, I did it verbatim, word for word. Is they didn't specify child anywhere in that there. So I repeated it just as it was in the order.
I understand what you're saying. However, legally, you have to actually identify. That's what the language says. But even tracking the language, you put her name and his name. There's no child's name and there's no location. The child's name is not as big of an issue as the location. That has to be mentioned on each one of the violations where they're supposed to exchange. It specifically says in 157.002, part A under C, a motion for enforcement, the terms and conditions of conservatorship or possession and access must include the date, the place, and if applicable, the time of each occasion of the respondent's failure to comply with the order. So on each one of those violations, you would have had to say what the place was according to the order. So if the order is dad's residence, it had to be outlined as dad residence. If it's mom's residence, it has to be outlined in terms of mom's residence or the public place, whatever location it is, it has to be mentioned in there. Otherwise, it's defective.
Even if she doesn't provide any information, he didn't know where the child was.
Even if your
got it.
motion, yes, he has to show, it's a very technical motion, counsel. So that's the issue.
Okay, I'd like to request a motion for leave to amend. Or it cannot, because shouldn't I be allowed to amend on the record right now, since we're still in the hearing?
Well, no, and that's another thing. You have already had an entire hearing, and I made a ruling. So there wouldn't be an amendment. You would have to file a new motion.
Okay.
And that's the reason why I wanted you all to go and have a conversation to see if there was anything that could be worked out, because the court couldn't give any relief that you all were seeking today pursuant to the law.
Okay. Well,
Okay.
we have information available now, and so we'll just do that.
Okay. All right. Now, Ms. Pennington, Mr. Stencer, before you all leave, do you have any questions about what your obligations are under this court order?
So we're just sticking to the same court order that was already in place.
The same order. Until an order is modified or changed, it has to be followed verbatim.
So it's no accountability on her end.
Well, I didn't say that. I admonished her. So that's the most I can do today.
She's not gonna do right until there's some kind of accountability.
You don't do right before then. You
Okay,
ain't
hold
doing it.
on. Y'all are not gonna argue back and forth.
I'm not, because it's funny.
I said what each of you need to do in compliance with the court order. That does not mean, Ms. Pennington, he can't come back and bring another motion. That does not mean, Ms. Pennington, if for any reason he violating the order, you can't bring a motion on him. But in terms of, like I said, the statute, I can't do anything with that.
I'll make sure my ducks is in a row. If there's a next time, I'll make sure.
Okay, so you all just follow the court order as it's written. You won't have any problems. If you can't follow it as written and you agree to do something else, your court order is flexible enough where it allows you to do that. But I just want to make sure it's clear that even if you all are following an agreement for a year and one of you decides you don't want to do the agreement anymore, the court order is still in place. You have to follow it at all times. It's the court order that is existing right now until modified.
So, Your Honor, for clarification purposes, you're not able to move forward on this at this particular time on the contempt, but we can refile it with the corrections.
Well, I can't tell you what to file or anything like that.
That's not what I'm asking. I'm just making sure that if there is an opportunity to refile with the corrections to move forward.
You can refile as many times as you need to. And Ms. Pennington, that's your right too. You all can file whatever you want to file to get before the court at any time.
Thank you, Your Honor.
You're welcome. Thank you all. You all are
Torian, call me.
Thank you. Have a great day.
Thank you. You too.
Thank you.
Torian, I'm going to call you.
God don't like ugly.
was on a different floor. Good morning.
Good morning.
Attorney Oyene, I think you're in the wrong Zoom. You're supposed to be with Judge Lee.
No, with you.
I don't have you on my docket today.
Yes, you did. You reset us for today.
Hold on, let me see.
An enforcement.
I don't have you on my calendar. Hold on, let me see. Give me your calls number. DF21
00827.
Oh, it's the wrong number. Oh, you have your own interpreter.
Yes, Judge.
Okay, so that's the reason it was removed from the docket, because my coordinator thought that you were requesting the court to get you an interpreter.
No, that's not me. It's
Okay.
it's the respondent's attorney. Miss, I just spoke to her a while ago. Catherine Estrada.
Yeah, she's here. Good morning, Attorney Estrada.
Good morning, Judge.
Okay, let's see. Who am I missing?
My client's logging on right now, Judge.
Is she on the Galaxy phone?
I think she said she was going to try and log on from her tablet because my paralegal is having to translate for her since we weren't able to get a translator for today, Judge.
Okay. All right, let me just rename her. Would you spell her first name for me?
It's Maria, Maria Mendoza, Mendoza.
Thank you.
That's not how she has it. She has it at Ma Guadalupe Mendoza.
I'm not sure why you have it on your pleadings as Ma, but I feel like the prior order had it as Maria Guadalupe Mendoza.
MA is an abbreviation for Maria that's commonly used.
Oh, okay.
Thank you.
Let's see what the, okay. I was just making sure the order matched. Am I also admitting Diana Castillo?
She's translating right now for Miss Mendoza, Judge, but she's not certified.
Okay. Miss Dunlap, would you mind translating for both of them?
I do not mind, Your Honor. The only issue is that we would have to utilize the interpreter feature on Zoom, and I think you have to do that before you start the hearing.
Okay.
Because unless you want to do all of this consecutively, which would be a little slower, but I mean, I can do both.
Okay. Yeah, consecutively may be best. So she's on the phone and we can see her here on the screen. I think that'll be good.
At your disposal, Your Honor.
Okay. Attorney Estrada, how would payment work for her?
So I actually filed a motion, Judge, to ask the county to pay for a certified interpreter. I filed my client's statement of inability to pay court costs as well, Judge.
Okay. All right. And Ms. Dunlap, you are certified, is that correct?
I am, Your Honor. I have a master license number 652.
Okay. All right. So everyone ready to proceed?
¿Todos listos para proceder? Señora Mendoza, usted está en silencio. Por favor, quítese de mudo.
Sí.
Right. Have the attorneys had an opportunity to speak?
¿Los abogados han tenido tiempo para poder platicar?
I did speak to The opposing counsel off the record a while ago, Ms. Catherine Estrada. Does she have anything to say to me?
Well, I just like to ask if have you all had an opportunity to speak to see if there were anything that you could work out? It's not required.
Yeah, and I mean, the only thing that I can tell him is that my client's not in agreement to modify the order based on any kind of agreement today.
Okay, all right. So both sides ready to proceed?
Yes, Judge.
All right, we are on the record in cause number DF 2100827. Councils, will you please announce for the record?
Kenneth Oyen, attorney for Alfredo Figorina Rodriguez, petitioner in this motion.
Catherine Estrada, court-appointed counsel for Miss Maria Mendoza, the respondent, Judge.
Okay, and the interpreter?
Juanita Dunlap, Your Honor, spelled DUNLAP, license number 652.
Okay, would you please raise your right hand? Do you swear to properly translate from English to Spanish and Spanish to English?
I do.
Thank you. With those who intend to testify, please raise your right hand.
Las personas que tienen intenciones de prestar testimonio, por favor, alza la mano derecha para prestar juramento.
Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
¿Jura usted que su testimonio será la verdad, toda la verdad y nada más que la verdad? Respondan sí o no.
Sí.
Yes, yes.
Okay.
Mr. Figueroa did not raise his hand. Señor Figueroa, ¿usted jura decir la verdad, toda la verdad y nada más que la verdad? ¿Nos escucha, señor Figueroa? ¿Nos escucha? He can't hear anything.
Try logging, have him log back off and try to log back in.
Por favor, desconéctese y añádese de nuevo para ver si eso arregla el problema de sonido. Cuelgue. Hold on, Your Honor. I'm going to have to write him a note.
Okay.
I think he did.
Judge, my client is in Minnesota. Maybe that's what's holding him up.
Okay.
Counselor, do you have a phone number? Maybe I can try calling him to see what the issue is.
Look. 214 457 2394.
You know, I'm going to put myself on mute and just try calling him and see if we can fix the issue.
Okay, that would be great.
He's trying to log back on now, Your Honor.
Okay. He he can keep his camera on, and if he wanted to give his testimony through the phone with you, that's fine.
Señor Figueroa, ¿nos escucha ahora? Okay. ¿Me puede escuchar bien? ¿Sí? Está usted en silencio todavía. Toque la pantalla y se va a aparecer un micrófono.
Okay, yeah.
Muy bien.
All right. And I believe now that you can hear us, let me swear you in again. Will you please raise your right hand?
Por favor, alza la mano derecha para prestar juramento.
Do you swear or affirm that the testimony
Alza la mano.
Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
¿Jura usted que el testimonio que va a presentar será la verdad y toda la verdad?
Sí.
Yes.
Thank you.
Gracias.
Okay. Attorney Oyene, I believe this is your client's motion. Is that correct?
Yes, Your Honor.
Okay, you all have 15 minutes aside. That will include any opening and closing statements should you choose to make any, and also your examination. Are there any preliminary issues that the court needs to take up?
No, Your Honor.
Judge, I would specially accept and ask the court to strike his motion for enforcement, Judge. Under Chapter 157, under 157.002, the contents of the motion for enforcement of visitation, Mr. Anya was required to state dates, times, places, and be specific with exactly how the order was violated, Judge. And in his motion for enforcement, the only two allegations are that my client did not register with FLP, and that basically that he was denied his visits. I did file an answer and a notice of affirmative defenses, Judge, which I know Mr. Anya advised me that he did receive and review. I did attach as Exhibit A documents from FLP that my client had obtained that show not only that she had registered and was in communication with them, but also that there was actually a visit that took place back in December of 2021, Judge. So I don't believe that Mr. Anya has perfected his motion in specificity, because the order designates FLP as the individual to basically determine when the visits were going to be and schedule them, Judge.
Okay, response?
Judge, if I may, respondent was supposed to register FLP. This order specifically states, the final order that we're enforcing from, that the visitation was supposed to commence December 31st, 2022, and is in my petition, second page, first paragraph, and she failed to register. The registration or the affirmative defense assessed by respondent said that my client did not specify the date. It could not, because she did not register on the date specified. She did go over there in July 2021. That was before the final order was issued. And that will not negate the fact that she failed to register or contact them. As for the documents the opposing counsel filed, at this time I will object. Not only is it in Spanish, it's hearsay document. So that does not negate my client to testify to what he knows in reference to visitation, which he was denied.
Okay. The court is reviewing the pleadings. Now, I can't specially accept his motion because the special exception has to be the first thing filed. Your answer was filed first, but the court will, so the special exceptions is denied, but in looking at the motion for enforcement, counsel, I would have to grant her objection to proceeding because the motion isn't specific as it needs to be pursuant to 157.002 that would put her client on notice of the actual allegations so she can raise defenses to it.
Okay, Judge, if I may, did you open the second page, second page of my motion? Where it says on September 12, 2022, the court signed the order. And that was when the order was issued. So,
right, but it has to, your violation has to actually track that same language.
Yes. My client cannot specify exactly the exact date, but what my client is saying that on so time, as the court ordered, she did not show up there to.
Hold on, counsel. Hold on. We're not going to go into the contents because the motion is defective. It doesn't track the language, and pursuant to 157.002, you actually have to specify time, date, manner, location. These violations don't do any of that. So the court would sustain the objection.
Judge, one more thing in that case. The original order, that was what was said. In that case, will the court modify modify this order so that it can be enforced? Because that was the language entered in the order on page 8.
Okay, the court made its ruling. And thank you all.
Thank you,
Your
Judge.
Honor, may I interpret what just happened?
Yes.
Señores, para que puedan ustedes entender, los abogados estaban hablando sobre el hecho de que la petición está defectiva. Entablaron una petición por incumplimiento, pero no se especificaron fechas, tiempos, modos locales donde se haya infringido la orden previa. Así que la abogada para la defensa, para la señora María, hizo una petición al tribunal que se denegara la petición por incumplimiento y la juez ha confirmado que esas órdenes según la ley, según los capítulos de la ley 157.002, el lenguaje de esa orden, de esa petición tiene que tener fechas específicas, el local y también la fecha, tiempo, manera y local en donde se infringió la orden previa. Así que por ahorita no se va a poder continuar porque la juez ha sostenido la protesta de la abogada defensora y no vamos a poder proceder hoy. ¿Entienden?
Sí.
Thank you all. You may be excused.
Gracias a todos.
Thank you, Judge.
You're welcome.
No te digo fecha.
Okay, it looks like we have one more hearing. I'm going to go into their breakout room.
Ernest?
Yeah.
Oh, did you get that text message from London? He said he thinks they might have an thing.
Oh, okay. I didn't see that.
He just
Move her to the main session. Is Attorney Ermi still out there?
Yes, Judge.
Okay, could you have him come in? Thank you. All right, Attorney Holland, it's my understanding that you all may have an agreement.
That's correct. I need to break out and talk things over with my client to get a few numbers down for sure. And then
Okay.
we'll be able to come back and advise the court.
Okay, great. I was just going to bring Attorney Ermis in here so he'll know, what's going on.
Oh, yeah. Thank you.
You're welcome. Hi, I just confirmed you all had an agreement.
We believe we do. We need to knock out some fine tuning on it. You know how it is. The attorneys have an agreement. So
Okay.
we need to make sure that the parties are.
Okay, so I'm getting ready to put her and her client in a breakout room so they can speak.
Awesome.
Okay.
Yeah, so I think we're there, and there were some procedural things where we probably haven't heard.
Okay. All right. So what I'll do is, when you're done with your client, just come back in and then we can prove up you all's agreement, if any, on the record.
Okay. Sounds great.
Okay. Thank you. You're welcome. All right. So I will be back. Okay, he's coming back.
Okay, yeah, I was just gonna be asked if I can be put in a breakout room with him because I got the details that he and I have to go over, and then we should be able to have one. I know that it's about to be noon. Do you want us to pop back in at 1:30?
No.
Oh, okay. I'm like, dude,
No, we're ready to get you all done.
thank you.
Okay, you need to speak to.
Opposing counsel.
Okay.
I like one of the things we're talking about is makeup days. And so I figured out how many makeup days, and we've got to iron out that schedule so that we can get it read in and have it be in agreement.
Is it okay if I call you on your office phone?
Oh, yeah. Yeah, we can talk that way.
Okay. All
Yep.
right. Thank
All
you.
right, thank you.
Yes.
ask to sit here while we're ironing things out. Is it okay if we announce that we'll work everything out in detail via Rule 11?
Only thing about that is a Rule 11 is it's not really binding.
I was gonna do it so that we include signatures for the judge so that when it's submitted with both of our signatures and our clients, it can be set as an order, an agreed order.
Well, you can't entitle it a Rule 11 agreement then.
Okay. What would you, and I'm respectfully asking, what would be a better title for that so that it doesn't like.
Order on motion for enforcement.
Okay.
An agreed order on motion for enforcement.
Okay.
Okay, so what we can do is go ahead and put the agreements on the record.
So where we're at.
Okay.
Our most important agreement, which I think we can at least put on the record, Ms. Holand, you correct me, is the parties are going to treat days when the school is out, even if they're in service or just out, as holidays.
Okay.
They have a really interesting thing where there's just days kids don't have.
It's like 3 weeks and then they either have a Monday or a Friday that's just off and it's not an in-service. So the way that a standard order is worded, it doesn't cover it. And so there's been some confusion and issues over who gets those days. And so what we're doing is agreeing that whoever's in possession of the kids then, either the Monday off or the Friday off, will be treated the same way as an in-service or holiday.
Okay.
So the person in possession will have the children. And then we've also agreed that there's makeup days to be made. And then the house that used to serve as the exchange location has been sold. So it's no longer something we can enforce. So we agreed to set the exchange location at a QT gas station. There's like a safe harbor Cameron area. And so they can do it there. And then the one thing that we aren't able to read in yet is based on the school calendar, it actually lets out about a week later than anticipated. And so by doing that, we actually have to figure out which days we can make up because the school calendar is off from what we believed it to be. So we don't have those dates to read into the record yet.
Okay, so we'll just prove up the agreements that you all do have.
And Ms. Holand,
yes,
if we also have in there that that dad does agree to take the children to school-related activities during his time?
Yes. And I believe that they have been doing that since the end of October.
Since you're involved.
Yes.
So if I would like to say that we're still hammering out the number of days and for the makeup, and then also the time for the makeup days.
Okay.
I think that's fair.
That's fine. So what you all will do is just put on the record the actual agreements and that you all are still working. It's still an agreement. You all are just working towards getting an order. I think that will make it easier.
Okay.
So we're on the record in cause number DF21023112. Councils, will you please announce for the record?
Stephanie Holen, bar number 24093618. I represent Antonio Zepeda.
Jeffrey Ernest, 24032159, and I represent Mom.
Okay. All right. I'll go ahead and swear your clients in. Will you please raise your right hand? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
I do.
Thank you. All right. We are set here today on a motion for enforcement, but it has come to the court's attention that there's been some agreements made by the parties that you all are going to put on the record. Is that correct?
That is correct, Your Honor.
Okay. All right. Who wanted to speak it into the record?
I'll do it if that's okay.
Okay, that's fine.
That's fine.
The parties have agreed that weekdays, when school is not in session, even if it is not a school holiday, will still be treated as a holiday for purposes of father exercising his visitation. Father has agreed that during his times, he will take the children to any school-related activities. The parties are going to exchange at a QT And we will get the address agreed to as we negotiate.
Okay,
But it will be close to that, or closer to that, or closer to Grand Prairie. There are some makeup days owed, but council and the parties have to get the number of days together. In addition, the parties are going to be discussing trying to get these makeup dates scheduled during the Christmas break. And I believe that is the extent of the agreements.
okay. Attorney Holland, is that the extent of the agreements?
Yes, Your Honor, for today.
Okay, so the court accepts the agreements between the parties and will look for an order.
Thank you very much, Your Honor. May we all be excused?
Yes, thank you. All right, good to see you.
You as well, Your Honor. May we be excused?
Yes, have a good day. Thank y'all for coming.
I don't see him very home.
You too, you too.
You always have a nice smile. You're welcome.
All right, so we are on
Joy.
break until 2 o'clock.
Oh, no, okay.